Ready, start. DW2 has independently corroborated this sequence. He testified that he had gone to the appellant's chamber at about 5:10 p.m. in connection with two workers' compensation cases. By the time he was leaving, he saw the appellant walking towards the toilet attached to the chamber and simultaneously observed the complainant entering the chamber. As he stepped into the veranda, DW2 encountered DW1 and both exchanged greetings. His account matches up with DW1's as each locates the other at the scene. Each describes the appellant leaving for the toilet and both place the complainant alone inside the chamber at that time. We note that both DWs were cross examined on possible bias but did not waver. They frankly admitted knowing one another but gave independent reasons for being at the office. Their testimony cannot be brushed aside as manufactured. It directly supports the appellant's explanation that the complainant took advantage of his brief absence to place the tainted notes in the drawer without any demand or acceptance by the appellant. This is pertinent as the High Court has completely discounted the testimony of DW1 and DW2 by stating that they would have appeared before the appellant in official capacity and thus might be inclined to oblige him. We find no merit in this reasoning. A witness's evidence is not to be rejected merely because he appeared before or dealt with the accused in an official or professional capacity, particularly when it was in course of their business that they visited the spot, that is, they are single inverted comma natural single inverted comma close witnesses. In the instant case, DW1 gave a full account of his visits on 25/9/1997 and 26/9/1997 linked to bonus disputes of his union, and DW2 explained his visit in connection with pending workers' compensation case numbers 11/1997 and 13/1997. We find that these are legitimate reasons rather than manufactured pretexts. Moreover, with respect to the quality of the evidence, both DWs provided mutually consistent accounts. This convergence on material details is not easily explained away as a product of bias. Both were cross examined, both admitted acquaintance with the appellant and one another within bracket and DW1 with the complainant bracket close, and both denied suggestions of fabrication. They have also stated that the suggestion that no one could enter or leave the office without the appellant's permission is incorrect, which directly contradicts the High Court's finding to this effect. Unless the DW's evidence is shown to be inherently improbable or contradicted by the record, it cannot be discarded solely because they were professionals who had cause to interact with the appellant's office. On the point of the testimony of the attendant Abbas, we note that he wrote a letter to the appellant on 27/9/1997 supporting the defense version, even stating that while the appellant was in the toilet, he heard the sound of a drawer being opened. He states therein that when he entered the chamber, he found the complainant sitting alone, and the complainant said that he had merely closed the drawer which had been left half open.